All right, I'm back. This is, I guess, episode two. A little bit impromptu. I didn't really, wasn't really planning on doing this today, but I got a little window and I went to office hours, got some good feedback, and so I kind of got, gone back through, and we've covered a little more NEPA and read a little bit more on that, so I'm feeling a little better with some of that stuff. Um, yeah, I guess I went back and watched the first video, and the audio is terrible. It looks bad, and it's hard to listen to. But I'm hoping. I think I'm standing in a. I think I was standing too close. I need to stand a bit further back, so I am standing a bit further back now. Hopefully, the audio will be at least a little better for this one. Still no PowerPoint. I actually did make a PowerPoint with the Jeffersonian survey grid as well as a railroad grant example, and also the Camfield versus U.S. Unlawful Enclosures Act. Just a little example. But I'm in a little bit of a rush right now, so I didn't, and also it just didn't work out. I don't know, yeah. But so hopefully I'll probably do one more before the exam, possibly maybe this weekend, and I'll definitely include the PowerPoint in that one, because not gonna brag, but I went a little crazy with the MS Paint and put some stuff that a kindergartner would think was pretty cool on there. So, all right, I'm just gonna get started because, like I said, a little bit of a rush here, so just gonna get started and kind of rip. Biggest part of feedback, from the professor, I guess, was making it more concise, cutting quite a bit out because this is an exam, so it's gonna be it's an hour 20, so it's going to be crunched. So definitely going to have to make sure to keep going. He said the information was good. I mean, all the information, I had a really good base. It was just a matter of building it up to a point, just cutting off, saying what I need to say instead of just totally information dumping. So I'm going to get ripping here and just start getting through this. Okay, first question again. Briefly describe two ways in which federal lands were historically disposed. How does this history of federal land disposition and retention help explain the crazy quilt of land ownership patterns in parts of Montana and the American West? So, first part of this one, I narrowed it down to two. First part, land grants to settlers. So there was a series of homestead acts that led to 285 million acres of federal public lands being patented for low prices or for free after meeting certain provisions. And then we had the land grants to railroads. Land granted to railroads in alternating sections within a certain perimeter on either side of the railroad. In the end, railroads received a total of 94 million acres in these alternate section patterns, throughout that and then during the disposition era. And then, okay, so as the U.S. shifts into the public land retention era, which kind of really started with the Taylor Grazing Act, and then FDR, he gave out his two executive orders that pretty much brought the rest of the public domain or public land into being retained. And then there was FLIPMA, which passed in 1976, which the Congress kind of stated that from that point on, all public lands would be retained. But anyways, off topic. As the U.S. shifted into public land retention era, sections of public land were left intermixed. So those public lands that were now being retained were being left intermixed with that the private holdings of the railroads, which with that checkerboard or that alternating pattern, and also the settlers too, who had gotten lands under the Homestead Acts. Now there's these retained public lands intermixed with those, and today this has resulted in that mosaic we have, especially in the West, and especially where those railroad grants were historically. How does the history of the railroad land grants and the Unlawful Enclosure Act help us to understand the two parts of contemporary disputes about corner crossing and landlocked public lands? So, like I said in the previous one, railroad grants, the land's given out in alternating sections, and then with the Unlawful Enclosure Act, individuals they can't fence or use threat. They can't enclose. They can't prevent. The Unlawful Enclosure Act is an individual cannot fence, enclose, or use threat or obstruct someone from entering public land. That's it summed up. That's not the official language Congress used, but essentially, someone can't prevent another person from entering public lands. Where these two things kind of coincide today, today's the problems we got with these landlocked public lands and corner crossing. So, those railroad grants with those alternate sections results in, section of there's a section of public land can be completely surrounded on all four sides by private land that was formerly railroad grant. And that public land is only accessible diagonally via the corners from other public lands. So therefore you got your corner crossing. Now, under the Unlawful Enclosures Act, an individual cannot prevent another person from entering public land and using that public land solely for their use. So a private individual can't close off that section of public land that might be completely in landlocked on four sides by private land. That's kind of the two that's kind of what's led to the two parts of the contemporary disputes about corner crossing and landlocked public lands. Briefly stated, what is a checkerboard landscape and how did it happen? Provide one example of a management issue or challenge associated with checkerboards. All right, so kind of covered this a bit in the past couple, but a checkerboard landscape is made up of alternating sections of private and public land, and the sections of public land or even the sections of private might, only be accessible diagonally via the corner. Now, obviously, if there's a section of private land that's surrounded on all four sides by public land, they can still access that. Especially if there's a road or something, they can go through that public land. But if it's a section of public land surrounded on all four sides by private land, that's where it gets difficult because you only can access it diagonally via corner crossing, or if there's an easement in place. But that's not even part of this. And these landscapes, these checkerboarded landscapes arose out of the disposition era and those alternating sections of land given out to the railroads from the federal government in the railroad grants. And then a management issue that arises out of this is, accessing those landlocked public lands that are surrounded on all four sides by private land for, whether it's recreation or, any sort of resource management, getting in there and doing sampling or, checking out the fuels and all that, that's tough. And, you got to work with the landowner or, achieve an easement of some sort. But okay, just going to keep rolling. And that, that's also, the Iron Bar versus Holdings case versus Cape, the Wyoming corner crossing case is, very relevant example of this management issue that is currently ongoing today. For what purpose are state trust lands to be managed? State trust lands are to be managed for beneficiaries. Most often these beneficiaries are public schools and public institutions within a state. For what purposes are state trust lands to be managed? How did states come to own this land? And how is it generally distributed? What is the most common and significant beneficiary of state trust land management? So, for what purpose are state trust lands to be managed? I pretty much just stated that in the last question, but they're to be managed for beneficiaries, which is most often public institutions, which is schools and other public things. Okay, and how are they generally distributed? They were generally distributed via state enabling acts, part of the disposition era, going back to that, and this was kind of the third one outside of land grants to settlers, land grants to railroads, and then land grants to states. And states in their enabling acts were allotted a certain amount of land, federal land, was given to the states by Congress. And this started 1803. Ohio sets the precedent. They get one section per township of land from the federal government, and they are to use this land for the beneficiaries, which are schools. I think schools was what the language had specifically at that time was those were for schools. And then over time, this number does increase. Starting with California in 1850, it goes from one township to one section per township to two sections per township, and then eventually with Utah in 1896, it goes from 2 to 4 sections per township, and then even going on, Arizona had got that 4 sections per township, but they also got additional lands, which ended up equaling 14% of the total land area. Now that those lands were used for a wide variety of things, schools, insane asylum, and I think other all sorts of beneficiaries. And the most common and significant beneficiary of state trust land management is schools. Why is most federal public land located in the western United States? Why is so much of this federal public land intermingled with state and private property? Briefly describe one management conflict or challenge that results from such intermixed ownership. So, yeah, kind of, I guess, right off the bat, like the eastern, the Midwest in the east is a much more favorable climate. It doesn't take, you don't have to work near as much, it doesn't take near as much acreage to homestead to support a family. It's productive, much more productive soil and productive land. And so a lot of that land was claimed pretty early on in those early homestead acts, early preemption acts. And then, yeah, people, was moving west. Those lands were claimed fast. And then, okay, then starting, the retention era, which kind of starts with the Taylor Grazing Act, and then FDR's two executive orders, and then, officially the retention era, real, like, retention of public lands is with FLPMA. So yeah, the Taylor Grazing Act withdrew 80 million acres from the public land from being settled. It was to be leased for grazing. It was for grazing, so it could still be used by the public, but it would no longer be able to be settled. And then FDR followed that up with two executive orders that withdrew the rest of that public land from potentially being settled. And then FLPMA, like I said earlier, declared all public lands to remain in the federal ownership. Large portion of these, retained lands by the Grazing Act, FDR and FLPMA, are in the West, where it wasn't near as easy for homestead. It took for a homesteader to settle that land. It would take a lot more acreage in some cases to support a family. It'd take a lot more work. And then areas, it's so arid, desert, and it's just, it's hard. A lot of that land was really only applicable for grazing, so it just, it wasn't as prone, not as favorable climate to be settled near as easy. So, yeah, I guess let me go back to the question real quick. Okay, briefly. Why is this federal land intermingled with state and private property? Well, okay, we kind of got, this retained public land now is, intermixed. Let's go back to the railroad grant. That checkerboard pattern from the railroad grant, now you got these sections of federally retained land intermixed with that. And then you also got, private homesteads intermixed with the, federal land intermixed with those. And then you got your land grant, or your state grant, yes, land grants to states, intermixed too with that. So it's, all that retained, now that newly retained land is now, permanently intermixed with all this private and state land. And I think I've also, management conflict or challenge that results from this intermixed ownership. Like I said, I've kind of hit this pretty hard, but it's accessing that land is really, as a challenge, or it's contentious at least. It might, corner crossing physically might not be that difficult of a thing, but, you got the Unlawful Enclosures Act, and then, versus, a private landowner's right to the airspace above their land. Because essentially when you corner cross, you might not physically touch that private land, but you're going to pass through the airspace of it irregardless. The thing is, the private individual, though, is not allowed to prevent someone, physically or under threat from entering public land. So there's the dispute. And, Iron Bar Holdings versus Cape, or Camfield versus U.S. kind of exemplifies. Camfield versus U.S. is different, but I'm not going to get into that now. Maybe when I have the slideshow, I'd make it a little easier. How does CLEPI versus New Mexico help us to understand the powers derived from the property clause of the U.S. Constitution? What does this have to do with federal lands and wildlife management? So through the Constitution and the Property Clause, Congress has the power to make all needful rules and regulations respecting the territory or other property belonging to the U.S. In CLEPI versus New Mexico, the Supreme Court finds that the Property Clause also gives Congress the power to protect wildlife on federal public lands, state law notwithstanding. Therefore, under the Property Clause and backed by the Supreme Court, in CLEPI versus New Mexico, Congress has the right and rules to make regulations pertaining to wildlife on federal lands. In cases where state laws and federal laws coincide on federal lands, the state law must proceed. So in this, in CLEPI versus New Mexico, the Free Roaming Horses and Burros Act, as congressional statute passed pursuant to the Constitution, the Property Clause of the Constitution, overruled the New Mexico estray law. And I'm not going to go into the details of CLEPI versus New Mexico again, but on federal public land. Then the extraterritorial reaches of the property clause is, I think, a bit out of the scope of this question, at least. The U.S. Constitution Property Clause, the Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. Oh, wrong page. Okay. How does the Property Clause help us to understand the limitations presented to those states seeking the transfer of federal land to state ownership? Provide one example of the Property Clause power used by Congress and interpreted by the Supreme Court. All right, so in order for a state to have federal land transferred to it, Congress would need to approve that. So that's a huge hurdle, to get that approval. And then, Congress also isn't bound. They could get, a transfer of federal land through FLIPMA, but then, that's not, it's not a one-way transaction. There would have to be, the state would also have to give either some federal land or some state land to the federal government, and I think that that really pertains around like urban areas, where there's development moving in, encroaching, and also Congress isn't bound by the equal value appraisal obligations found in FLIPMA, so yeah, they don't have to. There's it's not like that even exchange that FLIPMA has, so likely if Congress were to, it'd probably be a kind of a lopsided trade, I think, in a blunt way to put it. And so like I said, if transferred through FLIPMA, the land's exchange must be of equal value or in the public interest. And so there's the challenge. It has to go through Congress. And I guess an example of the Property Clause power used by Congress and interpreted by the Supreme Court would go back to Kleppe versus New Mexico. We see the Supreme Court held that the Property Clause gave Congress the authority to make that Free Roaming Horses and Burros Act pursuant to the Property Clause of the Constitution. What part of the U.S. Constitution provides Congress the authority to enact the Unlawful Enclosures Act of 1885? What is the basic purpose of this act? So, the Property Clause, again, gives Congress, the Property Clause of the Constitution provides Congress with the authority to enact the Unlawful Enclosures Act. The basic purpose of the Unlawful Enclosures Act is to prohibit any person or entity from exclusive use or occupancy of public lands by enclosing the land with construction of a barrier or a threat or any means to prevent other people from using the public land, but they still use it. And the Camfield versus U.S. case is a great example of this, and if I had the PowerPoint, I would have shown it, but I don't. So maybe for the next video. In a nutshell, what is the Supremacy Clause of the United States Constitution, and how would it resolve a case involving a federal law in conflict with a state law? So the Supremacy Clause of the Constitution and laws made from it and treaties are the supreme law. Establishes that the Constitution, laws made from it, and the treaties made are the supreme law of the land. And this even kind of goes back to the the Property Clause in in Kleppe versus New Mexico. How that the Free Roaming Horses and Burros Act superseded the New Mexico estray law because it was constitutionally under the Property Clause, and then the Supremacy Clause gives that makes that raw law the supreme law of the land. It's kind of a 1-2 punch there. At least that's kind of how I'm interpreting it. And then so in cases of state law versus federal law, the federal law will supersede state law under the Supremacy Clause. And then here again, I got Kleppe versus New Mexico and how the Free Roaming Horses and Burros Act was established by Congress pursuant to the Property Clause. Free Roaming and Horses and Burros Act overrides New Mexico estray law pursuant to the Supremacy Clause. Article 3 of the Hellgate Treaty of 1855 governs the Confederated Salish and Kootenai tribes. It reads, the exclusive right of taking fish in all the streams running through or bordering said reservation is further secured to said Indians, as also the right of taking fish at all usual and accustomed places, in common with citizens of the territory, and of erecting temporary buildings for curing, together with the privilege of hunting, gathering roots and berries, and pasturing their horses and cattle upon open and unclaimed land. What two parts of the U.S. Constitution help us to understand the legal basis of this clause, and what does it have to do with the federal public lands and or the fish and wildlife management? So, first and foremost, the Treaty Clause, which gives the President power to make treaties with 2/3 Senate vote. And then the Supremacy Clause, which establishes treaties as the supreme law of the land. So, the reserved rights given in this section to the tribal members on open and unclaimed land is kind of a big component. And a little more history here. So, the Montana Supreme Court found that Forest Service lands fall under this category of open and unclaimed land. So, under the Supremacy Clause, the hunting and fishing rights reserved in the treaty, approved by the President with a 2/3 Senate vote, supersede the state regulations for hunting and fishing. So, tribal members can hunt, out of official Montana hunting seasons on Forest Service land, or open and unclaimed land. And that's, okay. I feel like I just blew through that one. I don't know. But how does an administrative rule or regulation differ from a statute? Where are statutes and regulations codified? So, a statute's written and passed into law by Congress, and is pursuant to the U.S. Constitution. And they are codified in the U.S. Code. Administrative rules and regulations are drafted by federal agencies pursuant to the statutes written by Congress that are pursuant to the Constitution. Agencies fill in the gaps of these statutes made through the APA. The regulations do have to go through the Administrative Procedure Act and judicial review, and they are codified in the Code of Federal Regulations, the CFR. How does an administrative rule or regulation differ from a statute? Where are statutes and regulations codified? Why does rulemaking generally happen? All right, so like I said, an administrative rule is written by agencies in the executive. These rules are made pursuant to the statutes written by Congress, and they must be made through the APA and go through judicial review. Statutes are broad framework legislation written pursuant to the Constitution by Congress. Regulations are often written because Congress doesn't answer all the questions pertaining, or they don't answer all the questions. They leave ambiguity in those statutes that they write, and that silence or ambiguity is kind of leaves some openness to interpretation for the agencies to write regulations. And it could be said that they write that ambiguity to defer to the agency expertise when making specific regulations about pursuant to those statutes. As discussed in class, the National Forest Management Act includes a provision related to wildlife. Forest plans shall provide for diversity of plant and animal communities based on sustainability and capability of the specific land area in order to meet the overall multiple use objectives. Describe the general process pursuant to the Administrative Procedure Act of 1946 that was used to write the U.S. Forest Service diversity regulations, and why were these regulations necessary? On what legal basis could the agency's regulations pertaining to the diversity regulations be challenged by outside interests? All right, so this is notice and comment rulemaking. First step, public notice. So they publish the proposed regulations in the Federal Register, which is like the federal government's daily newspaper of notices, updates, rules, and regulations that are being potentially put forward. Second, public participation. You got the notice and you got the comment. And that this is provide an opportunity for the public to participate and make comments. And so these meeting times will also be posted. Locations, times, or anyway the way that they can make comment will be also posted in the Federal Register. And generally, I think these all that'll be published together with the notice. And then third, judicial review. And they got the courts are basing they're on the arbitrary and capricious standard when it comes to reviewing these decision or agency regulations. So the first thing they might they're going to ask is there a rational connection between the facts found and the decision made? Then they might then they'll ask, is there a clear error in judgment by the agency? And then was there an important aspect of the problem and issue not covered? And so the regulations, okay, so going back to the diversity of regulations, those were necessary because the Forest Service needed to address the ambiguity of the word diversity in that statute, and what that all may encompass from a management standpoint. An outside interest may challenge the regulations as being arbitrary and capricious. They can bring that in court, and they might not see how the Forest Service came to that conclusion that diversity means that, means something. Or they might think that there was a clear judgment by the Forest Service, or maybe that they overlooked an important aspect or issue. All right, what is the judicial review provision of the APA? What does it mean when people say this is a deferential standard of review? What does statutory ambiguity have to do with this? Does this mean that federal agencies cannot be held accountable for their actions and decisions? Please explain with a real or hypothetical example. So the judicial review provision of the APA, courts shall hold unlawful and set aside agency action finding and conclusions to be arbitrary and capricious. And then we go back to those three questions that they use to look at these actions. Is there a rational connection between the decision made and the facts found? Is there a clear error in judgment? Did the agency overlook an important aspect or issue? And it's said that this is deferential because it is a limited inquiry. They're only looking at, is the agency decision arbitrary and capricious? And yeah, that's what I guess that would be kind of why it's referred to as deferential. And how statutory ambiguity plays into that is, Congress writes these statutes sometimes, not all the time, but they write statutes with ambiguous language or even silent on some things. So, and in a way to kind of defer to agency expertise when interpreting and writing their own rules. So it does make it it's So I think that's I'm just waving my hands around now. Okay. So I guess does this mean that federal agencies cannot be held? And with that statutory ambiguity, so that also kind of leads, I think, leads to courts deferring then, if there's that ambiguity in the language now, but maybe that not so much anymore after Chevron's been turned over. But historically, with that ambiguity in that language or in the statute, that has meant that they will defer to the the agency expertise. This doesn't necessarily mean though that agencies can't be held accountable for their actions and decisions. We go to that northern spotted owl versus Hodel, where the U.S. Forest Service decides not to list the northern spotted owl despite expertise from biologists and their own team that they had brought in to do the analysis, and so they decide not to list it, but then they don't provide the rational connection between their decision made and the facts found, and so they were ruled as arbitrary and capricious, and they had to redo it and they were remanded. All right, briefly describe one implication that may result from a public land law that is written by Congress in a relatively vague and open-ended fashion. So I guess an implication of this could be, a change in the executive branch, a new president's elected, and their policies are all different than the former administration. They bring in all these they bring in a new cabinet, and so they're, implementing new heads, of each agency. And so as these new heads are brought in, there's going to be a change in the focus of these agencies. So they're going to be reinterpreting some of those statutes written by Congress. They're probably going to be pulling back some of their regulations. Maybe they're putting in new regulations. Maybe they're changing old regulations. They're rewriting definitions. It's a lot. It's a lot of it kind of leads to uncertainty. And I think that was kind of one of the reasons why they undid Chevron, was to try to eliminate that uncertainty. At least that's what I think. That's what. I'm getting off topic. All right. Let's see. Moving on. So, use northern spotted owl versus Hodel to explain the arbitrary and capricious standard of review and explain the 2 to 3 questions the court asks in determining whether an agency action is arbitrary and capricious. So, pursuant to the Endangered Species Act, U.S. Forest Service or U.S. Fish and Wildlife Service has to review the northern spotted owl for possible listing. They conduct the analysis. They bring in experts and biologists and under the experts and biologists, and even after peer review, they determine that the northern spotted owl is due for is under threat of imminent extinction. But U.S. Fish and Wildlife Service asserts their own expertise and does not deem northern spotted owl in need of listing. But they all they don't, in their listing they only assert their expertise. They don't provide the analysis of how they got to that decision. what led them to not list, to deem that not worthy of being listed. So, first question, is there a rational connection between the facts found and decision made? No, the U.S. Forest Service didn't provide that rational connection. And no, so no expert analysis supporting their decision or, any data or anything, evidence. And then I guess the other two, like clear error in judgment and like an important aspect or problem or issue overlooked. I was having trouble kind of coming up with those ones, so I'm gonna stew on those a bit more. All right, so put simply, because I feel like with that one, the rational connection between the facts found and decision made is pretty clear there. Put simply, 1 to 2 sentences, what was the Chevron doctrine and how was it applied by the courts to a federal agency's interpretation of a law and a rule or regulation? So the Chevron doctrine, or also known as the Chevron two-step, was previously used by courts in the judicial review phase of APA. And it pretty much just it was the standard where, if a statute was written by Congress, was silent or ambiguous on the issue, the courts would defer to the agency, at least pretty much most of the time. If there were some examples of them not, but it was very deferential to agencies. And like I said kind of earlier, especially with that uncertainty when you got a lot of, change in the executive branch and things, you get that pendulum swinging, I can see maybe the reasoning especially with that, to repeal Chevron. Okay, decision in Loper v. Bright Enterprises, Raimondo. How did the decision in Loper Bright versus Raimondo change the amount of discretion generally afforded to federal agencies by the judiciary? What branch of government does this decision empower? All right, so biggest takeaway there is it eliminated the use of the Chevron doctrine by courts during judicial review, and therefore it reduces the amount of deference given to the agencies by the courts. So courts no longer must defer to agency expertise when a statute is ambiguous or silent. This then, in theory, empowers the judiciary to interpret ambiguity in statutes. Okay, there's Loper v. Bright question. I'm not going to go into the details of Loper v. Bright right now. Yeah, so he hasn't given that question yet. He was going to write that one, I guess. Okay, in a nutshell, what is NEPA scoping? Okay, so scoping is I kind of got a couple different, it's providing the public an opportunity to comment on an EIS throughout the NEPA process or the process of an action being taken by an agency. And then I also kind of found too, though, that scoping is it's the process of determining to what extent the environmental effects should be considered. Determining whether a federal action is major and significantly affects the environment, and it kind of looks at the connected and cumulative actions of an action, and then but I think it's tell the public what you're doing, what do you need to consider, and what should we be concerned about and analyze. I think it is, a lot of it is getting the public involved and letting them be vocal throughout the process. Transparency, I guess, in some ways. How is the principle of precaution to look before you leap integrated into the design of NEPA, and how is it implemented by federal land agencies? Please discuss Section 102 of the law and your answer. So Section 102 of NEPA is the section, the action forcing section of NEPA, and it essentially, it's the section that establishes that an EIS, an environmental impact statement, is required for all major federal actions. And in these environmental EISs, you're supposed to give out the environmental effects of the action, environmental effects that can't be avoided, alternatives to your action, and the effects those alternatives might have, relationship between local short-term uses of man's environment and the maintenance and enhancement of its long-term productivity, and then the irreversible and irretrievable commitments of federal resources which would be involved. So Section 102 is the principle of precaution. By requiring an EIS, it forces an agency to address potential environmental impacts of their action. By following the EIS requirements of Section 102, an agency is made aware of the potential environmental impacts that could occur from the action or its alternatives. So it is that look before you leap. 102 is kind of the look, it is the look before you leap, I guess, portion of NEPA. It requires people to really take a thorough look at, the consequences of their action. and then the consequences of the alternative actions too. All right, so why is it said that NEPA is a procedural law, and what does this have to do with Section 101, Section 102, Section 105, and the role of the courts interpreting NEPA? So yeah, NEPA is said to be procedural because it doesn't require a substantive result from an agency. I mean, if an agency completes the NEPA process and considers the EIS, they are not required to choose the environmentally preferable option. At least pursuant to NEPA, they're not. That's and then I'll get into that in a later question. So yeah, so like how this ties in, Section 101 is it's just the broad, strategic, aspirational statement from Congress. It solely provides the purpose and vision and values of NEPA. It's just, yeah, it's kind of just, I don't know, an introduction, but it's not like, it's not like Section 102 where it's the action forcer where it requires that, that EIS be made for major federal actions. It's that principal precaution. And then Section 105, which I was kind of just about to get into earlier, it states that NEPA is supplementary to other authorizations of federal agencies, so like the Endangered Species Act, and so that's kind of where yes, it is procedural, but it's supplementary to other acts and other law. I guess like in courts interpreting the role of courts interpreting NEPA, it does. With that EIS, and it still holds. That's another one I was kind of tripped up on. I'm gonna stew on that a little bit more. All right, moving on. What does it mean when people say that NEPA is procedural law? So a little repeat here. NEPA is said to be procedural because it doesn't require a substantive result. If an agency properly completes, the NEPA process and considers an EIS, they're not required to choose the environmentally preferable option. As long as they do the process, they're good to go. But they're like I said, with Section 105, it is supplemental to other agencies and actions, and then also the general public too, public litigation. Okay, here we go. Other statutes may impose substantial environmental obligations. Okay, so there it is. On federal agencies, but NEPA merely informs or merely prohibits uninformed rather than unwise agency action. Explain what the Supreme Court means by this statement, as found in Robertson versus Mytho Valley Citizen Council, and what does this have to do with Section 105 of NEPA? Does this mean NEPA is an insignificant law? So essentially what this is saying, like I was kind of reiterating what I've said in the past few, is like, if an agency follows the NEPA procedure, they're not required to make a certain decision based on the environmental concerns. However, there are other statutes in place to enforce environmentally concerned decision making. So Section 105, plays right into that. Section 105, says that NEPA is supplementary to other regulations. It's recognized in NEPA that NEPA isn't, it's not enforcing any sort of decision, but it provides that. Information published by the agency in the NEPA process can open up that decision to litigation, judicial review, and just other agency, and other acts. And so it's not insignificant. It provides agencies with informed decision making. It allows for judicial review, and it provides information to the public and opens the decision up to litigation. But it really does keep the public, informed and allows them to make comment and like I said, take it to the courts, and it's a very a transparency thing for sure. So what is a categorical exclusion as used in the NEPA context? What are the benefits of using categorical exclusions, and why can the use of categorical exclusions be controversial? Provide an example in answer. So categorical exclusion is an agency action deemed not a major federal action and found not to have significant impacts on the environment, and no EIS is required. These can be beneficial to an agency that's looking to save some time and resources by avoiding having to do an EIS. And if it is something, because from reading, it's a lot of agencies have these categorical exclusions that are already set. There's certain things that do fall into that, which I'll get into it a little bit here, but can be a good or a bad thing. But it can save some time for something that is maybe routinely done. So I guess why can the use of a categorical exclusion be controversial? well, there's the Holland Lake Lodge expansion, big a couple years ago now, but so essentially, yeah, that fell under. There was a proposal to expand the lodge quite a bit. I don't have the numbers written down in front of me, but it was a big expansion. They were putting in lots of new buildings, updating buildings, putting in restaurants, the whole ball of wax. Lots of stuff, and all that expansion fell under a categorical exclusion because the Forest Service, because it's in a it's in a designated rec site, or there's a clause where the Forest Service, where it's maintenance or updating of a rec site, if it's it can be categorically excluded. So, and what this meant was, since they didn't have to complete, they didn't have to do that EIS documentation, it pretty much limited, it really limited the opportunity for public comment and public feedback, which resulted in kind of a thunderstorm of people getting worked up, and hands off Holland was a big movement, and I don't know, I'm not really sure where it's at these days. I think it's probably dead, but I haven't heard anything in a while, and I don't see much about it either. So yeah, definitely with those category exclusions, though, I think the biggest thing is like taking the public voice out of it, or taking the public ability out of it, is definitely a big problem, negative. Describe one real or hypothetical example of how an outside interest might challenge a federal agency's implementation of NEPA as arbitrary and capricious, as it relates to one of the following issues: scale of analysis, scope of analysis, connected actions, adequate consideration of environmental effects, reasonable range of alternatives, the use of a categorical exclusion, cumulative effects, tiering, public participation, or supplementation of the NEPA process. Going into the reading from the book that I had referenced in the first video, and I'll probably put in the description of this one as well. Thomas versus Peterson, 1985, Jersey Jack area, Nez Perce, Idaho. Big case. It was so the Forest Service produced, I guess it would have been 4 separate EAs. Well, they first came out with an environmental assessment for a road that I think they had called it a logging road. And then they, subsequently after that was, went through, finding of no significant impact, they came out with environmental assessments for at least three logging units associated with, off that road. So that road was to provide access to those, logging units that all fell under, got environmental assessments, and then, finding of no significant impact, FONSIs. They found that individually, none of these can, individually, as individuals separate from each other, none of these constituted a major federal action, and therefore didn't need EISs. Again, taking some of that public comment and participation out of the equation. So, and this is definitely, this is a case of segmenting, a literal textbook case of segmenting, like I said in the last video. So, the timber sales wouldn't be possible without the road, and the construction of the road wouldn't make sense without the timber sales. So that's kind of how you determine if something's, therefore there are connected actions. And I guess here's a couple of the actual, why can't I think, CEQ, it's the people who administer NEPA, and I keep thinking Council on Environmental Quality, but for some reason that's not sitting right. Crew? No, not crew. I don't know. I think it's council. I'll have to double check on that. CEQ, here's a couple of CEQ definitions too of connected actions. So, cannot or will not proceed unless other actions are taken previously or simultaneously. Okay, so, the timber sales wouldn't proceed unless the road had already been previously built. And then here's another one. Are interdependent parts of a larger action and depend on the larger action for their justification. So the timber, the road itself is interdependent, or is dependent on the timber sales for its justification. Like I said, I'm pretty sure in the actual case, in the court documents from the case, they said that the Forest Service had actually referred to that road as a logging road when they proposed it. So, like I said earlier, timber sales wouldn't be possible without the road, and construction of the road wouldn't make sense without the timber sale. Therefore, it was a connected action. So through the lens, it would be challenged that this decision by the Forest Service not to produce an EIS for these connected actions was arbitrary and capricious. And then as another note, in the trial, in the case documents, it was also mentioned that there had been a precedent already set on this by the Supreme Court and the CEQ that roads and timber sales are connected actions and therefore require an implementation of, completion of an EIS. So in that sense, it also would be, arbitrary and capricious when you ask the question of, did the agency, did the agency overlook, overlook an obvious or, I can't believe I'm forgetting this now. Dang it. Okay, where are we here, Chief? Oh yeah, okay, yeah. Did the agency overlook an important aspect or issue or question? Yeah, they did. They overlooked that precedent. Well, then, yeah. I don't know if they overlooked it. Obviously, I think they were just trying to pull a quick one and avoid having to do the EISs. It seems like that is a little bit of a trend with the Forest Service from the very small sample size. So, I don't want. Yeah. So anyway, the Bureau of Land Management just released its proposed roadmap for solar energy development on public lands. Let's see. Okay, the press announcement says that no solar developments are authorized through this planning effort. Proposed projects are still undergo site-specific environmental review and public comments. I don't know if I even said, but anyway, so yeah, they released the programmatic EIS for the whole the solar roadmap, I guess, or their program-wide EIS. So what does this mean, and what does it have to do with NEPA tiering? So they had, like I said, they've completed an EIS for the overall program level, the programmatic EIS program. I don't know. Okay. Anyway, so yeah, the overall program, it considers it's a very broad. The programmatic EIS is very broad. It just considers the cumulative effects and the overall objectives, and addresses broad environmental concerns. So it's very broad. It's just program level. So, and going forward, this states that, no solar developments are authorized through this planning effort. Proposed projects will still undergo site-specific EISs and public comment. So, once they actually determine where they're actually going to be putting in these solar little farms or whatever, they're going to prepare, before they do that, they're going to have site-specific EISs at each of those individual sites where they're going to address, the local, more comprehensive, smaller, narrow scale, and, getting much more detail, EISs. And, tiering, this falls into tiering, by preparing, the program-wide EIS, addresses the broad environmental concerns and the action they do not have to do. They don't have to be as comprehensive at that phase as they would be in the smaller scale ones. But the site-specific EISs, they don't have to address quite the broad stroke questions that the program one, the programmatic EIS. So it's like the wide environmental concerns, and they just have to focus on the comprehensive EIS of an individual site. So and the CEQ encourages this practice, and they encourage it because, in order to reduce, repetitive discussions and to focus on the actual issues at each level. So yeah, you're not doing these site-specific EISs, but then you have to keep, we have to go back to the broad scale stuff, and of the program level. And I don't know if I explained that quite well. We haven't quite gotten to this quite yet in class, so I think this will be tomorrow or even Tuesday. But that's it. I speed ran that pretty good. Made it a little bit better time. And like I said, biggest feedback from the professor was, let's trim this down. You got to trim this down. There's a lot here. You got a lot of good stuff, but it's also, you're going to be on the clock when it comes to exam time. So definitely, trying to make some cuts here and trying to get this. And then, obviously I also got to get a lot of this stuff locked in too, memorized. I'm not going to be reading from a script like I am here. So that's why I'm kind of doing this, is one, so I can listen back to it while I'm at work. But then two, just reading through this, I feel like it's pretty helpful, and then working through it. So I think that's all I got for this. Like I said, I'm on the clock a little bit too, though I'm under the gun here. I got some stuff going on. So yeah, I know. It's like I said in the first one, I made this for myself, but if someone else happens upon it, thanks for watching. And like I said, check out the description for the book where I pull a lot of this the textbook from the course. Yeah, where I'll put that in the description. Then also, yeah, a lot of this information is also supplemented from class lectures here at the University of Montana, NRSM 422, taught by Professor Nye. So, thank you for watching, and yeah, have a good one.